A short final session where the order will be that I will speak first, Amir will speak second, and Russell Berman, as he opened it, he will close it and give us his remarks, because his remarks are obviously, at least from my point of view, weighty ones that I intend to listen to. So I have 6 points, and I'm going to try to make them as quickly, because I've tried to think how to summarize and say something individual. Now, first of all, it struck me how little we talked about justice and religion. How little we talked about different ideals. I was thinking of the difference between Judaism and Christianity, where in Judaism the law, as in Islam, has a quasi-metaphysical status, because law attaches to the religion and not to the state. You know, this is an old Eli Kiduri argument, but I think it has to be brought up. In other words, the law, per se, is a matter for the religious courts. Now, any one of us who grew up in a common law country really thinks automatically that law belongs to the state and is not a matter of religion. That's, I think, somewhat important because it relates to the second point, which is the question that arose today in the talk about Rorty, which is the question of, and arose also yesterday, which is the question of justice and culture. In other words, is justice culture relative or not? And culture was left somewhat underdetermined in our conference. You know, we talked about it as a sort of reference for everything else, but what is it? Does it include religion, for example? Does it include class? What kinds of things do we think of when we talk about culture? That was, to me, somewhat not clear. Now, the third point I want to make is this, that relates to another point, that what we substitute for culture very often is narrative. This is not only just the postmodern turn, it's the idea of whether justice is telling a story or whether it's transcendental and analytic in nature, and whether the codes are transcendental and analytic in nature. And of course, with narrative arises, and I thought that was interesting to me because I hadn't realized before, that the question of otherness, like who is the other, who is the excluded, always arises with narrative. It doesn't arise with the question of universal norms. It's a question of my story, your story. And because it always arises with narrative, therefore there's some kind of interaction between those two, and you have to think, is there such a thing as a narrative that can be a just narrative, a legal narrative, a correct narrative, or anything else, or does it sink into a morass of generalization? That raises again the issue of universal culture and particular culture, which we danced around over and over again, universal laws and particular laws. We heard about endless talks about how people think differently in different cultures, how they, how they have different values, and whether we can or cannot apply our universal norms to them. This is the classic Nuremberg question. You know, in other words, the Nuremberg question is, in fact, hey, what I did was right. The state commanded me to do it. Where do you get off telling me that it was wrong to kill all those Jews? And of course, if you get into a finely relative world where people say, well, you must have some absolute universal norms, and then the truly relative argument says, actually, no. And, you know, and in that case, you're stopped from saying anything. So I think there's an issue there that is unresolved, and it's very hard to resolve in my mind, because we all grew up thinking that Nazism is I'm using this advisedly, maybe I all grew up, thinking that Nazism was the embodiment of absolute evil, and this was the great trauma of my people and of all our families and everything else. And of course, for most people in the world, demographically, it does not resonate at all. For your Cambodians, it doesn't resonate at all. They have other traumas, other problems, other issues, not just other values. That leads me to two last remarks, one of which is this, which is that I was trying to think of what is a redemptive strategy, because when we think of justice as opposed to the law, we seek some kind of redemption, some kind of wholeness, some kind of salvation, some kind of, it's not just that law has been done, it's that we seek some kind of fullness. And I thought, is this, in the well-worn Kantian thing, is this because we have now found out the truth through a truth commission? Is this because we have agreed to moral values that we now find reaffirmed by our promotion of justice? Or is this because it was raised again and again in this conference, interestingly, aesthetics, which is that somehow you believe that there is something like an aesthetics of justice as well as a truth and an ethics of justice. And I think a future to this kind of concern must concern itself with what is the problematic as well as what is the possibility of an aesthetics of justice. does such a category even make sense? Can you apply the categories of the beautiful or the sublime or anything else to justice in a way? We do, and yet we're profoundly uneasy about it. This is my last consideration is this, and I want to switch for a moment to justice, to the law, which is this: whom is the law intended to protect? We have a legal code, we have laws, we have a procedure. We don't just go around killing everybody else that we don't like. And the question is, whom is the law intended to protect? Now, we say it's intended to protect the weak. Well, we heard many talks which show that it does not protect the weak that well. Well, you must know, law in our system is intended to protect criminals. And we have to know that. It's intended to protect wrongdoers. It protects us. But in order to protect us, it has to protect the people who are criminals, because that's the only way we can be protected from the power of the state. If the state can decide who is a criminal on arbitrary matters, then we have no protection. And therefore, the law that we have is intended to protect wrongdoers. I think that's something we don't realize that because we talk about justice in many social categories, but we have to think about that, the intimate connection between law and transgression. Because what law deals with, whether it's in commerce and whether it's in criminal law, is with transgressive behavior. And I think that's, and it's with transgressive behavior, and what kinds of transgressive behavior are permitted or forbidden, homosexuality, on and on and on. It's all about these kinds of issues. And that leads to the last question, which is, what is the relationship in law, and I think this came out in several talks, between perpetrators and victims, which is to say, who is a victim? Now, I've dealt especially in my lifetime with the German case. And to hear that many Germans tell it, especially of the older generation, they were victims. Not only that, by their sons in the SS were also victims. Forget the German Wehrmacht and the Nazis. Everybody was a victim. The Jews, well, we don't know who the Jews are. We suffered. And the point is, and you hear that in the Israeli-Palestinian dialogue too. The first victims are not the Palestinians, they're the Israelis who have to suffer because they're in this crazy situation. So there's this displacement of victimhood, and at the same time, of course, the displacement of victimhood means a displacement of perpetratorhood. And that's a very dangerous thing, because if Germans can be victims, then Jews can be perpetrators. I met Germans who told me quite sincerely, well, the Jews must have deserved it in some way, what they got, didn't they? Look at their historical behavior. I heard that comment again and again. And I think that's an important comment to realize. Of course, it's an anti-Semitic comment, but it's a displacement of responsibility for what happened onto the person to whom it happened. The Palestinians are to blame for what happened to them. That's the meaning of that. And of course, it's always, for Jews too, a little bit true, but not very true. Not true in any legal or justifiable or responsible way. It's responsible in the same way that women are women and men are men, so any violence between them is obviously justified because the violence of the stronger against the weaker is justified in that sense. And I think that's something that we have to consider very much, that when we use these categories of perpetrators and victims, we have to be careful, because when we adopt victim narratives, what kind of victim narratives do we adopt? Do we adopt German memory or Jewish memory? Do we adopt the rhetoric of the perpetrators? Do we adopt the rhetoric of the victims? What is the justice of my vicarious? Is it correct for a younger German to say he identifies more with the Jews or with the Germans? Because if he identifies with the Jews, is that a cop-out? Or is that the real quest for honest justice? And if he applies with the perpetrators, is he sympathizing with Lieutenant Jaus in Yellow-Russia, raping his way through the countryside? I think these are things that we have to think about very deeply, that this perpetrator-victim dialogue, which is of the essence of what we were talking about today, because it's in all colonial discourse, it's in all national discourse, it's in majority-minority relations. In all this, we have to be very careful of what we mean and to whom we attribute it and when perpetrators and victims. That's all I have to say, and I will pass it on to Professor Eschel.
Thank you, Doug. I'm going to be very, very brief following you, because I think you really placed a lot on the table. So I'll just say something about the beginning or the origin of this discussion we had today, conversations I had when I started zooming on her topic, on her dissertation topic, and hopefully soon the book. So it all started with asking the question about the relationship between narrative and ethics. That was the point of culture. And as she started reading and we talked together, we tried to explore this judgment of narrative and ethics more closely. And this is where, for me, it got to be clear that where I stand on the issue of ethics and thus on justice is pretty much where the neo-pragmatism, American neo-pragmatism stands. So I thank Leer for mapping the way he did in the morning the field. And I think what we saw these last 2 days, going back to Russell's lecture, is a tension between two approaches to the question of justice. On the one hand, we have good old physics, into which I would include someone like Judith Butler, believing that there is, in fact, something like justice out there in the heavens, toward which we all strive and we should work, and if we only work hard enough, we'll actually get there. On the other side, and I'm putting it somewhat bluntly, we have someone like Arendt. For her, Ruth, I agree with you, things are very messy. We have to deal with issues one after the other. We have to see the contingencies of ethical questions and thus the contingencies of the law itself. And we have to work very concretely one case after the other as we're thinking about ethics, justice, and what the law is. So for me, this is sort of the running tension we had these 2 days. Do we think of justice as something very stable, solid, and physics up there in the air, or does justice come in a way from the ground up, and we have to think of it very carefully? Michael, one case after the other, one school child and her, what am I doing with this car? What am I doing in Cambodia? Does it have any resemblance to what happened in Germany? Does it somehow relate to what happened between Israelis and Palestinians? I think it's all about contingencies. And if it's all about contingencies, as I believe, then the only thing we have to our disposal is good old pragmatism or good new neo-pragmatism. And Rodney has another beautiful essay, which would be, I think, very fitting in this context, where he talks about ethics beyond principles. And I think this notion of ethics beyond principles is something we all desperately need, not least in Jerusalem today. So I'm going to finish by sort of a laundry list of what I wish would happen in a future discussion, in a future conversation, what's kind of missing in what we had this day and a half. So I think that for me, it's clear that if we're thinking about what justice is, it's not enough to turn to legal discourse and legal mechanisms we have to our disposal. I think this is one lesson in post-45, post the catastrophes of the 20th century. We cannot rely on the legal system and legal discourse alone. We have to have a much richer, much thicker array of discourses we go to as we're thinking about justice. And I think literature is certainly very important and perhaps at the center of where we turn to, but we all know that we live in an age in which literature happens in all kinds of places, and I think one of the most interesting places today is television, actually. And we didn't touch on it, but I think that one of the most interesting, important sides to explore notions of justice and how conflicting notions of justice surface in the public sphere is television. It's perhaps as interesting as the novel was in the 19th century, and fulfills, I think, similar functions. Another realm I hope we would have more in the future is the realm of the visual arts. Obviously, photography, painting, and so on, but photojournalism and the effect and the impact war journalism has in our time. We all know the story about the poor Turkish child who we all see, lying on the beach in Turkey, I believe it was, where his body was washed out. I think this photograph, I don't have the data to support it, but I would assume that this photograph definitely pushed public opinion in Europe, especially in Germany, toward doing something about the problem of the refugees. So what do we do with the visual arts sort of writ large? Ruth thankfully brought us in the last paper, which is, I mean, shocking in a way, to the question of technology. I think, if anyone were to continue to think about justice as a problem, as a challenge, without thinking about technology, we're not doing, a lot of what we're supposed to be doing. So technology, in the case of surveillance, is very, very important. We heard about that. I think the whole problem of social media and what's happening in social media is incredibly central to this question. From what we see, in the talkback sphere, to Twitter, to other means of social media. How do we think about it? How do we conceptualize it? How do we, adjudicate it? Can we have laws against, certain way of thinking and writing in social media and so on? I think this is an incredibly important topic to think about. And I'm going to conclude with saying that as we're thinking a lot about the crisis of the humanities, and as we quench about the crisis of the humanities, both in the United States and in Israel and in Europe and elsewhere, I think that the discussions we had these last 2 days and the questions, Gabi touched on in his concluding remarks and some of the things I tried to say, some of the things Russell will say, point to sort of the obvious that the humanities are a side in which these questions were discussed, are discussed, and are bound to be discussed in the future. So anyone who's talking about crisis should ask her himself if there's not so much on the table for us to, think about and also to talk with young people for whom we're kind of responsible.
Russell.
Okay, well, the hour is late and I will be even briefer. But at the beginning of this concluding session, you heard Gabi engage in a speech act that explained why I'm speaking last. He said, because I started, I must conclude. I think that was an enactment of justice, right? Inherent in our notion of justice is some sense of equalization, of fairness, of symmetry, maybe even of restoring an original condition. There's a certain amount of lex talionis here. You started it, you finish it. So I'll try to do that, but I mean this seriously, that this really gets to some of the substance of what we expect in justice. Here are some things that I take away from our discussions, leaving the pondering. In Interdisciplinary, Arendt reflects on the phrase that not only must justice be done, it must be seen to be done. At that point, if I recall correctly, it's an argument about procedural correctness and court legitimacy. But after today, I realized we could read this as a suggestion that there's an aesthetic dimension. It must be seen to be done, not only in terms of visual arts, but I'll take aesthetic a bit more broadly and include what we've really focused on much more extensively, kind of a linguistic term. That is, justice is a speech act, like the one you saw Gabi make a moment ago. We talked about justice in conversation, justice in dialogue, justice in narrative. I suppose that's the implication of justice as a topic for the humanities. And that's all correct, right? And that is a research agenda that could be pursued. Let's not be oblivious to the fact that that aestheticization of justice is itself open to the criticism that just words are just words. We don't only want justice to be seen, we want to have justice done. And the question is whether the shift into language is a deferral of the verdict. Second, we also learned a lot about temporality, that justice is somehow a function of time. Justice is a process, der Prozess. Galili talked about the deferral of eschatological justice. I think there's an element of that in the argument that Gabi made in the afternoon about how first peace, then empathy, justice is only at the end of... And that is all correct. But there's, again, here too, there's an Achilles heel, that temporality is really a deferral, and deferral is a cost to the aggrieved. We do have, I've been listening to all of this with an American. I have no idea, but jurisprudential codes here in Israel. But the notion of the right to a speedy trial. But if justice is perpetually deferred, then my right is taken away, it's not fulfilled. I want to have this done now. This explains our discomfort with statutes of limitation. What is it about time that somehow heals all wounds and therefore acquits all guilty? Third, I've learned that there may be a conflict in assumptions about justice, which on the one hand lead us to want to have a determinative, definitive conclusion. Whether that conclusion is an acquittal or a condemnation, the carrying out of the sentence, we want the trial to come to an end. But at the same time, there's a sense of restoration, of restitution, even of reconciliation, as if the two parties are being brought together again. And I think this is an opening to that literary moment where the novelistic account of the pursuit of justice leads to an exploration of a gray zone and ambiguity where roles of perpetrator and victim are blurred. And I want to underscore that that's at odds with our expectation of determinative finding. Maybe that's just baked into the notion of justice altogether. All of that's pretty aesthetic, right? The literary aspect of the temporal aspect, this ambiguity aspect. So what I missed here is really what Amir said is what we should miss, and that is a discussion of justice and the state and the courts. And this sort of confirms the part of my thesis last night that we academics live in a world of apprehension about the state and therefore some degree of suspicion about the courts. Is this just a function of our intellectual standing, or is there something really amiss in the legal world? And I think the answer is yes. And it flies under the flag of legalization, of Verrechtlichung, that there's just maybe the legal system has taken on too much, and therefore undermines its own authority in an Arendtian sense. I wonder, as a non-lawyer, as a non-legal scholar, and certainly not as a judge, in terms of the American system, about the erosion of expectations of double jeopardy through the expansion of the federal criminal code. I wonder about the consequence of prosecutorial discretion. I have no idea if these issues have any pertinence in Israel at all. I wonder about the relationship of plea bargaining to pursuit of justice, which just seems to open up worlds of murkiness and corruption. And I notice the expansion of practices of mediation and arbitration, which are ultimately efforts by actors in civil society to step outside of the court system because the court system is seen to be insufficient. I don't think it's good that the court system is seen to be insufficient. There may be objective grounds for us to see it as insufficient, but then there's something to correct. I think that in the end, the attraction of an aesthetic discussion about justice is a function of the legitimacy crisis of the law, that it does not have the credibility that it ought to have. Therefore, I think that to pursue justice, we should pray for the well-being of good judges and professors of law. I'll conclude with that.
Thank you.